is racing. And even if what I'm racing for is a patent, that is what I'm hoping for at the end of the day is to get an intellectual property right, the fact that I am in competition with someone else to race for that intellectual property right actually spurs faster innovation, and not just faster innovation, actually spurs people investing in research, thinking they may be racing against someone doing exactly the same thing, to do something a little bit differently. Right? People try and they turn out to develop ideas somewhat differently than each other, and as a result we get a variety of different technologies from which we can choose. So I think there are reasons to be skeptical of the Schumpeterian story that it's always exclusion from competition, right? Protection from competition that is the driver of innovation. Sometimes it is, but sometimes it's actually competition that's a driver of innovation. Similarly, on the other side, we have increasing evidence that suggests that intellectual property laws, intellectual property rights, while they sometimes promote innovation, can also interfere with it in certain circumstances. Right? That particularly where we grant a bunch of different intellectual property rights to different players, we end up with a series of problems in the marketplace. We end up with a problem of patent thickets, which you can think of as sort of double marginalization problems at the vertical level, or Corno complements problems at the horizontal level. If in fact you need a bunch of different rights before you can get into a market to improve it, we've actually made it more costly and more difficult to get into the business of innovation if we've granted too many intellectual property rights. Now, none of this is to say intellectual property is bad. What I intend to suggest instead is that intellectual property sometimes drives innovation, but sometimes it can actually interfere with innovation, and that competition law sometimes drives innovation, as well as sometimes is at odds with innovation. So the story, dynamic efficiency on one side, static efficiency on one side, is insufficiently complex. Now, then all we have to do is figure out, well, when is it that competition drives innovation, and when is it that the promise of monopoly drives innovation? Right? Here we come to a bit of a problem. 25 years ago, George Priest famously said, economists can tell lawyers absolutely nothing about the role of intellectual property. We just don't know anything about how IP works. That's not true anymore. We've done an enormous amount of research into intellectual property, into its relationship to innovation. There's a wealth of learning. But the wealth of learning hasn't given us an answer to the question, is intellectual property good or bad? It's given us a wide array of answers. It has taught us, I think overwhelmingly, that innovation works differently in different industries, that it works differently for different types of inventions within those industries, and that intellectual property law similarly works differently in promoting or perhaps retarding innovation, depending on the industry and the circumstances in which you're talking. So, for example, different industries vary pretty radically in the ratio of invention cost to imitation cost. The basic story of intellectual property law is a story that says it's really expensive to innovate, it's cheap to be a copier, so everybody's going to want to be a copier and nobody's going to want to be an innovator. Right? And that story depends, I think, on the ratio between the cost of invention and the cost of imitation. If I can make it hard to imitate my product, I can keep it as a secret, I develop a process that's so intrinsic to the actual individual decisions I make in my factory that you can't replicate it without copying every one of those decisions, I don't necessarily need that much intellectual property protection. Right? On the other hand, if it takes me a great deal of effort to create something and it can be copied like that, by putting it on the internet, well, now I've got a much stronger problem, a much stronger public goods problem. Depending on the industry you're in and depending on the technology you're in, that cost ratio is going to vary pretty dramatically. Right? In the pharmaceutical industry, we take enormous investment to develop new drugs, in part because of the nature of the drug business, but in part because of the regulatory barriers we put in the way of getting those new drugs on the market. We've created a set of incentives, I think rightly so, that make it easier for generic companies to make follow-on equivalents, but in doing so, we have created that cost ratio differential. Right? We've created a circumstance that makes it easier in life in various respects to be a generic company than to be a brand-owning pharmaceutical company. By contrast, you know, if what I'm doing is creating a kind of clever new software tweak to an existing product, even though it may be pretty easy to copy that software tweak, if I don't invest a lot of money in it, then there's perhaps no great need for intellectual property protection. Let me give you an example. There's a Google everyone's familiar with. Right? There's also a service called Google Instant, which deployed in the last year or two. And so as you're typing your search query, Google figures out what it is it thinks you're going to ask, and it starts showing you search results before you actually finish writing down what it is you're searching for. That's a kind of clever feature. Somebody, an undergrad at Stanford, wrote a program to do the same thing for YouTube. Right? I'm searching YouTube for videos, and it starts giving me YouTube search results while I'm still typing the search query. This is a useful feature. It's a valuable thing. Took him 3 hours to write it. He actually bet one of his dorm mates that he could do it in an hour, and he lost. It took him 3. And then he released it to the world. And this is a valuable product. It's easy to copy. But if the invention cost is 3 hours of coding time, it's not clear that we need 20 years of exclusivity to reward or incent that particular behavior. Now, we've also got differences by industry in a variety of other areas, such as the existence of other means of appropriation. Right? Am I getting paid in some other way? Can I keep my competitors out for a period of time from the market, not by use of intellectual property, but by some other means? If I can, well, then I may be able to recoup my investment costs in making inventions without ever having to rely on classical intellectual property. Maybe I can do this by keeping the invention secret. Maybe I can do it by getting a structural advantage from being the first one on the market, and so on. And here again, I think we see some pretty substantial industry-specific differences on whether that's a plausible story for protecting your product. Right? Some inventions are capable of being kept secret. Right? We have, or at least we think we have, Coca-Cola treated as a trade secret for over 100 years, and despite the fact that it's widely available, nobody seems able to copy it directly. People periodically claim they have done so. Nobody, I think, has sort of demonstrated it successfully to my knowledge. By contrast, if you're the inventor of the wheel, and your big idea is that it's round, well, you've got an invention that you can keep from the world, but only until you actually start to get it out there in the marketplace. And the moment it gets in the marketplace, anybody's going to be free to copy that thing, absent some intellectual property protection. We've also got differences in the regulatory structure, differences in sort of market-based barriers to entry. In the pharmaceutical industry, you can't just start selling a drug without FDA approval. That's not true in the rest of the world. Right? You want to start selling a product that's a knockoff of somebody else's product, go ahead. You might get sued for violating the intellectual property laws, but even if you get sued for violating the intellectual property laws, no one outside the pharmaceutical industry stops selling their product while they wait and see whether or not that patent lawsuit is going to be successful. It would be unheard of to pull Microsoft Word off the market because it's facing patent suits saying, well, this feature of Microsoft Word is infringing a patent, or to pull an Intel microprocessor off the market for the same reason. And that, I think, leads us to the second point, which is that the patent system itself works differently in different industries. Right? How well it protects innovation, whether it does so too well, these are all things that differ pretty dramatically by industry. They differ first and foremost by the relationship between patents and products that are sold. In the pharmaceutical industry, I create a new chemical entity, a new drug, and I get a patent on that drug. Now, I may try to get some additional patents on various other aspects of that drug, the delivery mechanism and so forth. I may kind of try to extend the life of my patent term by adding some patents later on, but the patent covers the product. And pretty much that's it. In the semiconductor industry, Intel lawyers will tell you there are 5,000 patents out there that cover anything we do. Right? If we build a new microprocessor, somebody's got a patent on this particular circuit layout, and somebody's got a patent on a different circuit layout, and these people have patents on different means of packaging the chip, and these people have patents on different means of producing the mask that then is used in photolithography and various and so on. And that means, I think, that the way the patent system works in those industries is fundamentally different than the way it works in an industry that's much closer to one patent, one product. All right. In particular, that gives rise to a holdup problem. All right. If I can stop Intel from selling its microprocessor because its microprocessor uses my patented invention, and if there are 5,000 different people, all of whom have that right, the business structure and the effect on innovation and creation of intellectual property is going to be pretty radically different than if there is one and only one patent owner, or even 2 or 3 patent owners you have to deal with in order to produce your product. Right? So one of the things that we've seen that drives, I think, a lot of the current debates over patent reform between the information technology industries on the one hand and the life sciences industries on the other hand is how many patents are out there that people have to deal with. But we also see substantial differences in the use that people make of those patents. Right? Are they, in fact, enforcing their patents in order to exclude competitors? That's what we do in the pharmaceutical industry. Right? I use my patent rights to keep generic competition off the market. Very few people do that in the IT industry. And when they do it, they find it's almost always a mistake. Right? In most industries, there's a detente between established players. Google and Yahoo and Microsoft really don't like each other. They don't sue each other on their core patents covering various technologies. Intel and AMD don't sue each other. And they don't sue each other because it turns out that if you've got so many patents and you're each using this complex interrelated web of technologies, you're all infringing each other's patents. Right? They don't sue each other for the same reason the US and the USSR didn't blow each other up during the Cold War. Right? You can kill me, but I can kill you too. And that means, in turn, that in those industries with this complex interrelated web of patents, it turns out that patent litigation is primarily driven by the non-practicing entities, aka patent trolls. People who don't actually make a product themselves, but who own a patent and assert it against the ones who are successful. And that, in turn, I think has a very significant effect on the relationship between patent law and innovation in those industries. We've got other differences as well. If you read a chemical patent or a genetics, a DNA patent, a scientist in that field can read that patent and tell you what it covers. Here's a chemical entity. Here's a group of chemical entities. I know what's in that group, and I know what's outside that group. No one can read a software patent and tell you with certainty what it covers until after the district court and then the Court of Appeals has actually interpreted those patent claims. And even then, it turns out we're going to fight over the interpretation. Right? We don't have a language in software that allows us to write patent claims that provide certainty as to what it is that the patent law covers. And that, in turn, the combination of the number of patents out there, the fact that most of the people who are going to assert them are non-practicing entities, and the fact that nobody can know whether or not what those patents cover,